A of the Medical Board of California, and I'm going to ask for a roll call. Ms. Moore, would you please be so kind as to do that?
Dr. Solomonson?
Here.
Dr. Bishop?
Here.
Dr. Diego?
Here.
Mr. Serrano Sewell?
Present.
Dr. Yip?
Yes.
Mrs. Yaroslavsky?
Present.
We have a quorum.
Thank you very much. I want to welcome everyone to the Panel A meeting of the Medical Board of California and introduce our Administrative Law Judge, Amy Yerke, and turn the meeting over to you. She will explain the rules that we're going to operate under, and I expect everyone to pay close attention now.
Good morning, folks. My name is Amy Yerke, and I'm an Administrative Law Judge with the Office of Administrative Hearings. The first thing I'd like to do is call the case. We are on the record in the matter of the oral argument from the accusation against Ronald Lawrence Leon, MD. This is agency case number 12-2010-205-506, Office of Administrative Hearings, case number 2012-020-910. Today is Thursday, April 25th, 2013. The time is approximately 10:02 in the morning, and we're located at the Hilton Hotel in Los Angeles, California. I'm going to go over very briefly some of the rules and procedures for this morning's proceeding. So based on Title 16 of the California Code of Regulations, Section 1364.30, which is entitled Procedures for the Conduct of Oral Argument. Please let me remind you that the arguments here today shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the party to clarify the arguments, but may not ask questions that would elicit new evidence. And then for everyone's edification, the sequence and the time limitations are as follows. First, the respondent licensee and or his or her legal counsel shall be limited to 15 minutes. Second, the Deputy Attorney General shall be limited to 15 minutes. Third, the respondent licensee's rebuttal or that of his or her legal counsel, which shall be limited to 5 minutes. And fourth, the Deputy Attorney General, who shall be limited to 5 minutes. All right, so do we have Mr. Hodges here?
Yeah, sure.
Are you ready to proceed, sir?
Yes, you are. Can I get counsel to state their appearances for the record, please?
Robert Hodges on behalf of Respondent Leon.
Deputy Attorney General Jane Zack Simon.
Can you spell your name for me, please?
Middle name is Zack, Z-A-C-K. Last name is Simon, S-I-M-O-N. And Jane is J-A-N-E.
Thank you very much. Okay. Bear with me, folks. I'm just setting my timer here. Mr. Hodges, are you ready to begin?
Yes, Your Honor.
You will have 15 minutes.
Thank you, Your Honor. Good morning, ladies and gentlemen. It's my pleasure to represent Dr. Leon in this hearing. We're here today to discuss the underlying facts of an accusation that was heard by Judge Ruth Astle in Oakland over a 4-day hearing, and the decision, the recommended decision that she made, which was non-adopted by the board. It is fairly simple in terms of the factual basis of the allegations and the accusation in this matter. It arises out of conduct by Dr. Leon in terms of contacting and initiating and maintaining a social relationship with a former patient who we refer to as Y, Mr. Y. Mr. Y was, at the time of initially being treated by Dr. Leon, a board-certified psychiatrist, a patient at a clinic in Jackson, California, in Amador County. He was treated for depression and anxiety, given medication by this physician. He was seen by this physician on 4 separate occasions during a roughly 8-week period of time that he sought treatment at that clinic. He was then lost to follow-up in March of 2006. And there was no contact with this patient, by the patient with the clinic, or by the patient with Dr. Leone, or Dr. Leone with the patient at any time until April of 2009, when Dr. Leone was on Facebook looking for a former acquaintance with a similar last name. He saw Mr. Y's Facebook page. He sent a message to him asking him if he was the former patient or the same Mr. Y from Amador County. And that initiated what then became a 9-week social relationship between April of 2009 and terminating their last face-to-face meeting in June of 2009, but some text messages and emails continuing until July, when all communication stopped. It was conceded at the hearing, and is conceded here today, that a social relationship between a physician, specifically a psychiatrist, and a former patient is not permitted by current and ongoing and long-standing principles involving psychiatric care with patients. And for good reason, because of issues of transference, because of the superior-subordinate relationship that exists in such a relationship. And so, for a long time, physicians have avoided such social relationships. It's further conceded that any sexual relationship with a former patient, current patient, is absolutely intolerable. It's an egregious act for lots of reasons, and it was conceded at the hearing. The evidence at the hearing of alleged sexual conduct between Dr. Leone and Mr. Y was to be the testimony only of Mr. Y, as denied by Dr. Leone. Mr. Y contended there was sexual contact on 2 occasions during a total of 4 visits that these 2 adult male gay members of our society had, and once at his house, once at a cabin in Tahoe owned by Dr. Leone. That was the testimony. The experts in the case, Dr. Berg for the state, Dr. Dolgoff for the respondent, agreed that any sexual conduct was an extreme departure, simply stated. It was also agreed, but there was some discussion that even a social relationship could be a departure. Dr. Berg taking the position that any social relationship, other than bumping into someone at a store or school, but any ongoing social relationship would be an extreme departure. Dr. Goldberg said, no, that's not true. There are 2 categories of conduct here, simple departures and extreme departures, and he categorized it as simple, but he did state that in the category of simple departures, it was on the higher end of simple departures. The judge found in her recommended decision that there was evidence to support both the sexual conduct and the social relationship, and issued a decision that I think, and I doubt that the Deputy Attorney General thinks, or the Medical Board at this point thinks, enforcement at least thinks, is satisfactory. The decision calls for revocation with 5 years of probation. It calls for educational courses, including the PACE professionalism course or its equivalent, a ethics course either through IMQ or PACE or its equivalent, 40 additional CME units per year, and reporting of the conduct and the outcome to the Chief of Staff of each hospital or facility where the doctor has privileges. Why is that not adequate? Well, it is adequate. It's adequate to protect the safety of the public. And as you know, under BMP Code Section 2229, the objective of any disciplinary action is to protect the public, balanced against the need for rehabilitation of the licensee. Well, what do we have here? We have probationary period, during which time there are terms and conditions to be complied with. The 40 hours of continuing CME is to be determined and approved by a probation officer, and it is to go to the issues involved in this case. So we know that he's going to be further educated on that basis alone. We know that the prescribing course, the ethics course, the personal boundaries course, and the psychiatric examination required by Judge Astle all go to rehabilitating the licensee. There's really no reason for the other things that perhaps the DAG is going to argue, which would be immediate suspension or actual suspension, a longer period of probation, perhaps outright revocation. No need for that at all. I would invite the panel to ask any questions of me, to ask any questions of Dr. Leon that they desire to ask. He's here today, prepared to discuss this case in its entirety with any specifics with regard to his involvement, why it occurred, how it occurred, and his current understanding. Before you do that, I want to talk about one thing that was raised by counsel's brief, in which she indicates that there is no remorse, no candor on the part of this respondent. And I disagree. He has taken a professionalism course, and he took that professionalism course prior to the hearing, and he completed it. He stated his remorse at the hearing. He was consistent. He has denied the sexual involvement from day one, including civil litigation, including the medical board interview, including the hearing testimony. Absolutely consistent all the way through. The right that he has to deny what he says did not occur cannot be viewed as lack of candor. He conceded and admitted the social relationship that existed, how it came to be, and for how long it was maintained. Remorse is going to be evident when you hear him talk to you about how this has affected him if you ask him those questions. His practice is at stake, his career is at stake. This is a 30-plus year physician whose career has been without blemish, without any sustainable actions before this agency. So I would ask you at this point to address any questions to me that you wish, or any questions to Dr. Leon. Thank you.
Thank you, sir. Would you like to proceed?
Yes. Good morning. I think under either scenario, whether you accept the administrative law judge's determination that based on her analysis of the evidence and her assessment of the credibility of the witnesses, that there was in fact a sexual relationship between Dr. Leon and his former patient, or whether you believe, as counsel suggests, that it was simply an inappropriate social relationship between a psychiatrist and his former patient, the penalty in the proposed decision is inadequate to address the egregious departures from the standard of practice that were established in this case. As a starting point, the evidence does establish that there was a sexual relationship between these two individuals. And that evidence is not, as counsel has just told you, simply based on the testimony of the former patient. The former patient, it should be noted at the outset, was found by the administrative law judge to be credible. She had a chance to observe his testimony, to observe his demeanor, and she found that he was credible and believable and that he testified honestly. Now, there was a lot of other evidence. Dr. Leon's Facebook messages to his patients, and these are all set forth in some detail in our brief, established that he contacted his former patient, and then he set about to invite him for dinner and drinks. He promptly informed this young man that he was single. He dangled out concert tickets. He said he wanted to catch up and go have a drink. He took him on overnight trips. He took him out to dinner. He invited him for weekend stays at Dr. Leon's home. The text messages that are set forth verbatim in our brief refer to dating, they refer to relationships, they refer to drama. They make statements like, "I don't like to be owned." It's also noteworthy that this patient told both his mother and his treating doctor that he was in this relationship at the time it was going on. So it is not a situation where we were just looking at who is more believable, Dr. Leon or his former patient. We were looking at the question of witness credibility as bolstered by independent evidence that was admitted in evidence at this hearing. Assuming that you conclude, as the administrative law judge did, that based on this evidence, there was a sexual relationship between this board-certified psychiatrist and his former patient, and that the patient is telling the truth, this is where the administrative law judge kind of didn't finish the thought in the proposed decision. Then you also have to conclude that Dr. Leon has not been candid in his dealings with the medical board. And he has not been forthcoming about what his interactions were, his inappropriate, unethical, and unprofessional interactions with this former patient. And if you conclude that, I think you have to reach the decision that that lack of honesty, that lack of candor is simply inconsistent with the safe and ethical practice of psychiatry. Now, the ALJ concluded that it was somewhat mitigating that although she believed that this conceitedly unethical, inappropriate relationship took place, that the fact that Dr. Leon had practiced for a number of years without any similar incidents somehow is mitigating and means that it's not as serious as it otherwise would be. Frankly, that is an offensive notion, that every psychiatrist gets one free bite, gets one sexual relationship. Those cases where somebody does get a chance and is given a second chance should be reserved for those cases where the physician steps up, takes responsibility, and admits what the physician has done that was wrong, not for somebody who tries to evade, points the finger at the patient, and is less than candid. And unfortunately, that's the situation that we have in this case. Now, if you accept Mr. Hodges' invitation to say that this was simply a social relationship that was conceitedly inappropriate, but it was not a sexual relationship, we still have some serious problems that the proposed decision does not adequately address. Dr. Leon is a board-certified psychiatrist. The very notion that somebody could practice psychiatry after the training that goes into achieving board certification in complete ignorance of the ethical rules that govern his practice, and with such a superficial and erroneous understanding of concepts such as transference and boundaries it's just not believable. It doesn't pass the sniff test. It's not believable that anybody could be that ignorant with that level of training and those number of years of practice. But if you do accept what Dr. Leon says in that regard, that he simply didn't know any of these things, it's hard to imagine the type of remedial program that could address that level of willful ignorance. The decision also doesn't address the fact that the ALJ made a finding that Dr. Leon did dispense sample medications to his patient without maintaining any treatment record, without communicating to the prescribing physician, and the proposed decision does nothing to address that finding. The proposed decision also doesn't really address the fact, it mentions the fact and makes a finding that Dr. Leon's candor in another area was found to be lacking. Dr. Leon went out and got, I believe it was 68 character letters from a number of people he had known throughout the years to say, to submit in evidence at this hearing. And we, again, those are set forth in detail in our brief, and I won't belabor it, but the theme that emerged from those letters is that Dr. Leon misled all of these people about what the nature of the charges are. By the time he came to the hearing, Dr. Leon had no choice but to acknowledge that regardless of which type of the two relationships occurred, it was unethical and it was inappropriate. Yet all of these letters, they're basically a series of potshots at Dr. Leon's victim, talking about what kind of person would level such false charges against a pillar of the community, that these are, it's very easy for an unscrupulous person such as this patient to take advantage of Dr. Leon. That type of continued misleading conduct is not sufficiently addressed by this proposed decision. If you find that there was no sexual relationship, the minimum penalty that could address the factual findings that were established by clear and convincing evidence in this case would be a revocation stayed with a lengthy suspension while Dr. Leon takes the steps that would be necessary to try to instill some level of professionalism in him. Probation with close monitoring and supervision, which is wholly absent in the proposed decision. He takes a few courses and he has a psych eval, and there's nothing that provides monitoring or supervision. Instead, it turns him loose to continue in a private practice completely unmonitored. There's no provision for psychotherapy. It's hard to see what a psychiatric evaluation could accomplish. Somebody can go through an evaluation, have no diagnosis, come out cleared on a psych eval, but still not have an ethical compass or any sense of professionalism. So as I said, the proposed decision has an incomplete thought. It doesn't deal with the corollary to finding that the patient is credible. Doesn't go on to conclude the train of thought that Dr. Leon was not. And I'm happy to answer any questions, but I have nothing further.
I'd like to clarify for the record, did the accusation allege charges of dishonesty with regard to Dr. Leon's candor?
We didn't know at the time what his testimony would be. That was something that the ALJ was left to deal with at the hearing.
That doesn't answer my question. Did the agency then amend, as they have the right to do prior to submission?
No.
Okay, so there was no charge. Because I want to, you're asserting that there wasn't a finding made, however, or it sounds like you're asserting there wasn't a legal conclusion drawn. However, if there was no cause for discipline, then neither the ALJ nor this panel can make a new legal conclusion based on an allegation that is absent from the accusation.
No, my point was that the penalty imposed has to deal with the evidence that was received and the credibility, the relative credibility of the witnesses.
And along those lines, was there a charge in the allegation regarding, you had mentioned dispensing samples, either negligence or record keeping or anything around that those facts? Were there any charges specific in the allegation with regard to that?
Honestly, I don't remember off the top of my head. I can look at that and address it.
Certainly, take a moment and let me know.
I don't think I have the accusation with me today. I believe it was charged as negligence.
Okay, thank you. You still have 3 minutes remaining. Is there anything else you'd like to say?
No, Your Honor.
All right, thank you. Mr. Hodges, your 5 minutes begins now.
Yes, Your Honor, thank you very much. Let me return to the question that you raised about the accusation, and I believe that neither of those issues were alleged in the allegation. Well, let me turn to incomplete thoughts by the ALJ as described by the Deputy Attorney General. In fact, the ALJ's decision addresses each and every issue raised by the DA, the Deputy Attorney General. There's a prescribing course requirement which goes to the issue of whether or not there was some error or oversight in prescribing samples, which of course Dr. Leon denied at the time of the hearing. There was no evidence other than the plaintiff, complainant, testifying that samples had been given. There was no samples produced. There was no track record of where those samples, if he ever got them from Dr. Leon, where they came from or where they went. So that evidence was at best slim. But the prescribing course will address that. Issues of professionalism, issues of knowledge, all addressed by the professionalism course, all addressed by the requirement for the ethics course, all addressed by the PACE program requirements. There is no reason to assign what I assume is being implied a practice monitor or supervised practice requirement. This doctor has a solo practice in his office doing medications. He also works for the county at the mental health clinic in the same capacity where he's on staff. Other psychiatrists are there. These allegations don't arise from his care and treatment of a patient. They arise from behavior with a former patient outside the context of his practice, and therefore no practice monitor is required. All of the requirements here are significant. They're required to be accomplished within either the first 6 months following adoption of the decision or within the first year. The 40 extra annual continuing medical education units is a significant requirement on the part of a physician in addition to the 25 that have to be accomplished each and every year. The period of probation is 5 years. As you're all aware, probation can be terminated early on petition if everything has gone right, but that's not a guarantee. The probation here may well last the entire 5 years given the seriousness of the allegations here. So any lengthy, more lengthy probationary period is absolutely unnecessary. And then lastly, actual suspension. What does actual suspension do? It punishes the physician. It deprives him of income. It deprives patients of care that they require. There's no reason here, and the ALJ found there's no reason for actual suspension. Thank you. I think my time's up.
Thank you.
I think I just heard the suggestion that there should be no requirement of any kind of supervision or monitoring because really this was not a practice issue. This was more related to private life. That misses the point. This absolutely had to do with Dr. Leon's practice. AY may no longer have been his patient in that he was providing treatment as a psychiatrist on an ongoing basis, but he was a former patient, and the whole point of this case is not that Dr. Leon did something in his private life that was wrong. It is that Dr. Leon inappropriately interacted with a patient. As the board's expert explained, once a patient, always a patient. He lacked that basic understanding, and in so doing, he engaged in extreme departures from the standard of practice, and he violated ethical standards. So it is not accurate to state that this is really a matter of his private life and there's no reason to supervise his practice. The best Dr. Leon can hope for is that the board finds that he was simply woefully incompetent because he lacked the basic knowledge about what the applicable standards are. If ever there were a case that called for some kind of supervision, this would be that case. But my final remark will be that probation really is only appropriate in those cases where the board has some assurance that the doctor can be rehabilitated, that the doctor will be a reliable and above all candid probationer. Otherwise, it's an exercise in futility and is simply not in the public interest. Dr. Leon has failed the candid test in this case. Nothing further.
All right, thank you. Dr. Leon, would you like to make a statement to the panel?
Yes, I would.
All right, then I'm going to swear you in. If you can please raise your right hand. Do you swear or affirm that the testimony you are about to give will be the truth and the whole truth, so help you God?
Yes, I do.
Thank you. Please go ahead.
I wrote this last night because I'm really nervous about this whole thing. And first of all, I want to apologize to all of you for being here. I'm totally embarrassed and ashamed that I find myself in this type of situation.
Sir, before you get started, I just want to remind you two things. One, if you could speak up, perhaps we can pull the microphone closer to you. And then the other is, you're welcome to read from that, but sometimes when we read, we tend to speed up. So I'm going to ask you to read nice and slow so that the reporter can take down everything that you're saying.
Okay. Okay, I'm sorry.
And you can sit if you'd like to.
As I said earlier, I want to apologize to everyone for being here. I'm very embarrassed and ashamed that I find myself in this situation because of my stupidity. I want you all to know, as I have always said from the very beginning, from when this whole thing started, and I told Bob when he told me that he was accusing me of having a sexual relation, that I had no type of sexual relations with that man. And that is the truth, no matter what the perception is. I realize that I've made a big mistake. I recognize that my conduct was not what is expected of me as a professional. And although I thought being a friend would help him, I know now that the perception is not what I intended or ever thought it would be. I also know now, and should have known then, that I could not have a friendship with a former patient. I've always known that about current patients. I just wasn't thinking of it in those terms. I recognize that the rule is no contact with any patient, be it current or former. Since this has happened, I've spoken to fellow psychiatrists about the fact that there is simply no contact, no matter how innocent, with former patients because it's not allowed. I know and understand the issues of transference arise in such relationships and that such relationships could cause harm, even if unintentionally, to the patient. I've taken a boundaries course recommended by my attorney, not to avoid punishment, but to learn about my deficiencies and to correct them. I also know that even social environment can lead to hurt, and I never intended to do that. I know that he is a victim of my poor judgment, not me. I should never have placed anyone in that type of situation where my intentions were misconstrued, and I am so sorry. I can tell you without any hesitation that you will never find me in this type of predicament or hear anything bad about me. I am willing to accept the decision and terms by the judge and comply with every single one completely. I am a physician who cares about my patients. I'm not a bad person. I do not want to harm anyone. I want to provide the best possible care to the people that need my help and who I know need mental health services. If you allow me to continue, I guarantee you that nothing like this will ever happen again. I promise. Thank you.
Thank you, sir. Do any of the panel members have questions, either of the attorneys or of Dr. Leon? Perhaps I'll start on my right, Mr. Sewell.
None, Your Honor.
Dr. Yip?
I'm trying to find the record. Did you attend a boundary course or ethics course in New Jersey?
Yes.
And
Yes.
I read a line there. There's a concern about your attendance there. It was a 2-day course. Did you attend all the classes, or there was a problem with attendance?
It started Friday and Saturday and Sunday, and I was at every class.
So
And we had
the way it says there's concern about his attendance, but I guess you attend every courses every day then.
I attended every course every day, and prior to that we had a workbook that we had to read and complete, and essays that we had to bring in when we first got there. And then another essay that we had to do at the end.
Dr. Yip, I was just informed that the way the process works is that a doctor would either receive a complete or an incomplete, and I believe Dr. Leon received a complete, so we appreciate your question, but it's not relevant. Thank you. Did you have any other questions, sir? All right. Dr. Salmonson, anything from you? All right, Dr. Bishop and Dr. Diego. No questions. All right. Well, then I believe at this point, we're going to conclude the proceeding, and the panel will enter closed deliberations. So we'll go off the record now. Ladies and gentlemen that are in the room, I'm going to ask everyone